The courtroom opens with tension thick in the air. Lawyers shuffle papers, defendants wait for their fate. Every case here carries a story, mistakes, hope, and justice. Watch closely as the judge sets the tone for a long day of decisions where every word could change someone's life forever.
After speaking with the prosecution in this case, it sounds like we may be able to resolve with some misdemeanors. I was able to make contact with Miss Foster Tucker with regard to her scheduling in terms of keeping all these cases together if the court prefers to do that. I was not, however, able to get a hold of Mr. Quinn, so I don't know his schedule, but I don't know if the court.
I only have one case before me.
I understand there are co-defendants in this matter, Your Honor.
Oh, I
apologize.
Okay.
And those co-defendants are Mr. Davis's brother and E. Williams. I don't know the first name. I'm sorry. I don't have it.
Earl Williams.
Earl, thank you.
All right. So you're looking, okay, gotcha.
Aaron Davis.
And my understanding is that Ms. Foster Tucker's plan is to adjourn this as well.
All right. Then I'll adjourn this to November 25th, 2025, 9 a.m. That's a Tuesday. And if the people could just let me know when the others are called up and we'll put them over to that same date. Bond will continue.
Thank you, Your Honor.
All right, thank you.
Thank you, Your Honor.
Court calls case People versus Brian Gerard.
Morning, Your Honor. Raymond Cook from People.
Your Honor, Alexis, my assistant public defender appearing with on behalf of Mr. Gerard, who's approaching. Mr. Gerard, could you say your full name?
Brian Gerard.
Thank you.
Your Honor, I do have a green sheet here, as well as a stipend order to allow the treatment, if you would consider it. And we are just requesting a very brief adjournment, so that we can work out a resolution.
I don't have a problem releasing him to treatment, but he would need to be on a tether.
Understood. No objection to that, Your Honor.
Well, okay, good. So if I won't sign this order, if you could include that in the order to me, then
Yes, I
won't have
will
a problem.
update it.
All right. And you wanted an adjournment on this, so.
Yes.
A subtle exchange, a signed order, and a man's freedom hangs in the balance. The court allows treatment, but demands control. It's a classic courtroom dilemma: mercy versus caution. Would you grant a second chance knowing it might backfire, or keep him behind bars to play it safe?
Well, the record should reflect you've got a bench conference in this case. I will sign the order as you presented it, given the other circumstances of the other cases. I will also grant your request for an adjournment.
Thank you, Your Honor.
I think we're done.
All right.
Otherwise, I have to listen to more of Miss Apple. Court calls the case People versus Gerald Dorsey.
Assistant prosecutor. People.
Assistant Public Defender Anna Apple, hearing on behalf of Mr. Dorsey, approaching now. Please state your name for the record.
Gerald Dorsey.
Thank you, sir. All right. What are we doing?
We have a resolution in.
Oh, I see. Yeah. I have a plea form in front of me that indicates that the defendant will be pleading to count 2 of retail fraud, second degree. The 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct.
Yes, sir.
May I have him sworn?
Right. Do you solemnly swear to affirm the testimony you're about to give the whole truth and nothing but the true self you got? Yes. State your name. Gerald Dorsey.
All right, sir. It is this court's understanding that you're going to plead guilty to the charge of retail fraud in the second degree.
Yes,
That is
sir.
a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that becomes the maximum fine. You understand that?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes. I thought it was this.
Pardon?
I thought it was, okay.
Yesterday, what could be the period without them?
Okay.
Okay. You understand that,
Yeah,
sir?
I understand. I just been going to this court, so I didn't know. She's just telling me about going to this new court.
Yeah, we're sick of you. No. All right. No, you understand Judge Valvo would be handling the
Yes, sir.
sentencing in this case, although I'm taking the plea. All right. Understanding all of that, do you still wish to plead guilty?
Yes, sir.
All right, to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
All right, you signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form. You'll see a copy. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or
A guilty plea for stealing sunglasses worth $27. The judge's calm tone meets a nervous voice. Small crime, big consequence. This moment isn't about theft. It's about accountability. One decision seals his fate. What do you think is justice fair? Or does the system sometimes punish too deeply?
4 Briarwood Circle, City of Ann Arbor, Washington County, State of Michigan, that being the sunglass hut? What did you do that makes you think that you're guilty?
Took a pair of glasses.
You did what?
Took a pair of glasses.
You took a pair of glasses and
Yes,
you
sir.
tried to walk out without paying for them?
Yes, sir.
All right. And the value of those,
I believe they were like $200.
was it in excess of $200?
It was about $207.
All right. And the store was open to the public at the time?
Yes, sir.
You didn't have anybody's permission to take that property?
No, sir.
And this property you took was property that was offered for sale by
Yes, sir.
them? Those ones that you put on the podium, those aren't the glasses, right?
Oh, no.
No, okay, I'm just,
No.
okay, I just thought I'd ask. I just thought I'd ask. Okay. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of your sentencing, if indeed you commit misconduct as defined under the Michigan court rules, you would not be entitled to any sentence evaluation and or recommendation, and the court would not be bound by that. And you would not be entitled to withdraw your plea. You understand that?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this?
None of the people are aware of it.
No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied now.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be December 2nd, 2025, 9 a.m. That is before Judge Valwell.
Okay.
Bond will continue. Okay?
Thank you, Your Honor.
Court does call the case of the People versus Taiwan Griggs.
Kenneth Overwater, Assistant Prosecuting Attorney for the people.
Stephanie Hannah on behalf of Mr. Griggs. Mr. Griggs, would you please state your name for the record?
Taiwan Griggs, Grand Rising.
Hello, Mr. Griggs. She actually.
Taiwan Dominique Griggs.
Okay, sorry. Thank you, Your Honor. I have forwarded some mitigation information to the prosecutor in this case. I'm asking for,
I guess it's up a preliminary exam.
we're going to set up for a preliminary exam, Your Honor.
Both of them?
Yes, Your Honor.
Is all discovery complete?
Yes, Your Honor.
People, other witnesses available the 18th.
I expect we shall.
Preliminary examination will be set November 18th, 2025, 9 a.m. before Judge Washington.
Your Honor, can we address bond? I do believe the last time we were here, the court was, or the prosecutor's office believed new charges were coming. It's my understanding those new charges have been
The court grows heavier as new charges surface mid-hearing. The defense pushes for treatment. The prosecution stays firm. The judge must weigh compassion against control. It's not just a case, it's a test of faith and rehabilitation. Would you believe in change or trust only the record?
as the court's where my client does have a substance abuse issue. You said you would consider it. I can prepare an order and I will prepare an order if the court is inclined to allow him to go to treatment.
I don't have a problem with that. Needs to include that there's a teller and that he will be returned to the jail if he doesn't complete.
Perfect, Your Honor. I'll get that to your honorable court.
So preliminary examination, the 18th, before Judge Washington. And bond will continue, and I'll sign that order when it comes.
Thank you, Your Honor.
Thank you. Court calls case, People versus Daryl Gardner.
Assistant Public Defender Hannah Apple. Mr. Gardner. State your name for the record.
Daryl Gardner.
Your Honor, Mr. Gardner is asking that this matter be set for a preliminary examination.
Did you want to deal with his violation first, or?
What is this?
I got this.
That's what was there. I signed in at the thing. Put the money to pay him, so he wouldn't let me test.
We have to get the money.
Okay, I'll get it. They got me scheduled to come up there Monday.
This coming Monday?
Mhm.
Okay. Your Honor, Mr. Gardner reports that he's scheduled to go back to community corrections for his intake and be able to pay for testing on
When?
Monday.
Yeah.
When is he scheduled to go back? Mr. Allen?
He reports that he is scheduled to go back on Monday.
When was that done?
When did you schedule that?
The day after I got out of jail, I went right up there.
Talked to her this morning, correct?
I think so. I talked to somebody this morning on the phone on the way here. I don't know who it was though.
That's Agent Dozier, I believe.
Oh, yes, the agent, yep.
Did you schedule that with her today?
No, I scheduled it with the lady that I saw when I went up there. She scheduled it for some agent for Monday coming up.
Your Honor, as the report indicates, looks like he talked to Agent Dozier this morning regarding that. He reports that he's scheduled to report on Monday for
Why didn't he
testing.
go in before?
What do you-
He
Well,
reports that he did.
His indications of what he said to community corrections are very disturbing to me. Because it's an absolute lack of cooperation.
They said you did not.
What made him supposedly call this morning? Because that would normally have been included in here. It's not included in here. We received this communication regarding the violation at 9:32 this morning. So if he had an appointment, I'm sure they would have let us know.
Gardner stands before the court, insisting he tried to comply. But the judge sees through the excuses. Bond revoked. 3 words, total silence. It's a chilling reminder that justice doesn't wait for promises. What's your take? Fairness or frustration? This is the courtroom's cold reality in action.
The witness is available the 18th.
Yes, sir.
Talked to Agent Dozier this morning.
I talked to somebody on the phone, yes. I don't know their name. I was on the bus on my way here.
Your Honor, that's all the information that I have to present to the court is what's in the report. And he states that he had a phone call with Agent Dozier this morning regarding his
And
non-compliance.
he's telling me that he's set for an intake on Monday.
Yes.
Yes.
Preliminary examination will be set for November 18th, 2025, 9 a.m. That's before Judge Moore. This time, what I have here is a violation. And at this point, you haven't been over to test at all since your release.
Yes, I did. They said
You haven't submitted a test.
I didn't. I tried. They wouldn't let me. They told me because I didn't have the money, they wouldn't test.
Bonds revoked, defendants remanded. If we find out additional information, then maybe I'll reconsider that.
Your Honor, I'll reach out to Agent Dozier to
Court calls the case of the People versus Barack Howell.
Defendant Overwater, Assistant Prosecuting Attorney with People.
Your Honor, Alexis Plumai, Assistant Public Defender, appearing with and on behalf of Mr. Howell, who is approaching. Mr. Howell, could you say your full name?
Hello, my name is Barrick Howell.
Thank you.
Hi.
Your Honor, I do have a green sheet to turn over. I am just requesting a brief adjournment. Weeks. Mr. Howell unfortunately was not accepted to mental health treatment court, so I am working on an alternate.
Alternate plan. All right. Without objection, probable cause conference. November 20th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you. Court calls case of of the people versus Aaron Grable. It's your fault.
What? I wasn't even
No,
here.
I know. You should have been here to catch the cop.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Grable, who's here via Zoom, Your Honor.
Mr. Grable, can you state your name, please?
Aaron Grable.
All right, what are we doing?
Your Honor, I have submitted a green sheet. I'm asking to adjourn this matter 2 weeks. I have spoken with Mr. Overwater. I think a resolution is in sight. I'm going to provide some more information to him and let him follow up on that, but I think we're well on the way to resolving this.
November 25th, 2025, 9 a.m. Without objection, bond will continue to execute.
Thank you, Your Honor. I'll get you a call when I'm out of court, Mr. Grable, okay?
All right.
Thank you, Your
Okay.
Honor.
Court does call the cases of the people versus Dale Miller.
Logic replaces emotion as the judge rules on mental competency. The defendant is deemed competent. Just one line, but it decides everything, whether a man stands trial or waits in uncertainty. Justice isn't just about guilt or innocence. It's about understanding what those words truly mean.
Deputy Chief Public Defender appearing with and on behalf of Mr. Dale Miller, who approaches. Mr. Miller, when you're ready, please state your name for the record.
Dale Joseph Miller.
Honor, today's the date and time set for competency review. Is the court in receipt of the letter from?
Yes, I'm receipt from an October 24th submission to the court.
We have no further evidence to present to the court.
Your Honor, people have no further evidence and stipulate the use of that report and ask the court on the.
All right. This time, based upon the review of that report, the defendant would be deemed competent. Court will order so that the defendant now can understand the nature of these proceedings and the nature and objects of these proceedings, and can rationally assist in it. But therefore, the defendant is deemed competent.
Thank you, Your Honor. We will prepare orders to that effect.
Today.
Yes, we'll have top people on.
Okay. And what would you like this set for now?
As soon as possible.
Okay.
Probable cause conference.
Probable cause conference. Set probable cause conference in this matter then for November 20th, 2025, 9 a.m.
November 20th. All right. Let's see.
Bond will continue. Okay.
Thank you, Your Honor.
Thank you.
Yeah.
Court calls case People versus Alicia Cargill.
Good morning, I'm Rob Tico on behalf of Ms. Cargill. Judge, this is a situation. This case has been going on since August. I've had several visits out at the prison with her. I don't think her earliest release date is till for another 9 years. I've sent her all the discovery. She was insistent on seeing the video. I had a visit set for 8 a.m. this morning. I was told by prison officials she did not want to see me today. Speaking with her, I know she's objecting to the police report, which we went in detail. Can I just set an exam in this matter, Judge? And can we?
Well, I need her here to set an exam. They signed in, she would not come to the room. And then eventually the facility signed out.
What should we do?
Well, I'm going to adjourn it over. I mean, if she doesn't, then you have to figure out something if she doesn't want to participate, but I'm not going to just set it for an exam if the defendant's not participating or is not here.
Okay. Can we adjourn it out to the 20th?
Well, they're going to have to do a new writ and they're going to have to make sure that she's going to actually participate in this. I'm not going to have everybody go through work and her just decide she's going to try to do it her way. So you'll have an opportunity to talk with her. I'll adjourn this at this point out to December 4th, 2025, 9 a.m. And that doesn't interfere with the defendant's release on anything because she's not going anywhere.
Okay. All right. Thank you.
Court calls case People versus Renee Hall.
Brown String on behalf with Ms. Hall.
Your name, ma'am?
Renee Hall.
Thank you.
Did you get my green paper?
I did, Mr. Brown.
We're requesting.
Unlike
adjournment.
Shanaza, yours are right on time.
Thank you. We're requesting adjournment. The co-defendant is Mr. Gay, Thomas Gay. So you want to do the same date?
What date was that? 25th? Yeah, that's what I thought.
Thank you.
All right. Probable cause conference will be adjourned November 25th, 2025. 9 a.m. Bond will continue.
Thank you.
That is a Tuesday, by the way.
Oh, Your Honor.
No. What? What were you gonna ask? You were gonna ask to approach?
Yes, very briefly.
That never's the case with you, Brown. Come on.
Yes.
Thank you.
Thank you,
You're welcome.
From pleas to revoked bonds, this courtroom session had it all: pressure, humanity, and the weight of judgment. Every ruling carried its own story. Which moment stayed with you? Let us know in the comments. Hit like and subscribe for more real courtroom stories and justice breakdowns.